A warm good morning to one and all.
Good morning.
It gives me a great joy to welcome you all to the second day of this two-day international conference on language, literature, and humanities. Before getting into today's session, I would like to extend my gratitude for your energetic participation and cooperation throughout the first day of this conference that was held on St. John's College of Arts and Science, Amandivalai, Tamil Nadu. Without any further delay, to deliver the first plenary lecture, I would like to invite Dr. Shalini Kashmiria, Assistant Professor, Department of Law, Himachal Pradesh University, Shimla, to put light on the topic Changing Dimensions of Relationship Between Law and Literature in the 21st Century.
Am I audible to everyone? Am I audible?
Yes, ma'am.
Is the PPT visible to everybody?
Yes, ma'am.
Thank you so much for giving this opportunity and a very good morning to all of you. The topic that I'm going to interact with you today is changing dimensions of relationship between law and literature in the 21st century. In common understanding, if we talk about law and literature, usually it is understood that they don't have any kind of relation with each other. When somebody tries to understand law, uh, we have the notion that law is basically based upon logical interpretations and rules and regulations, and it is beyond the scope of literature, which is purely imaginative, fictional, narrative, and descriptive. But when we try to understand these two concepts, although these two are different from each other, but we can say that they are the sides of the same coin, and they have a very strong relation with each other. Before understanding what is the relation between them and where law exists in the literature, let's try to understand what law actually is. So if we try to take a look towards the concept, we'll find that law basically refers to some legal principles, no matter they are regulating civil or criminal offenses, which are made by the legislature of a state for the purpose of maintenance of the society. And its purpose is to serve the common good, that is good for the society, not a particular individual. Law is meant for the society at large, good of people at large, and is not person specified, and it can be substantive law as well as the procedural law. Now, what is substantive and what is procedural law? There are, for example, we have certain rights being given by the Constitution of India to us, like we, in general understanding, like the right to life, the right to privacy, the right to education, the right to equality. So whenever there is violation of these rights, whenever there is violation of these rights, at that time we have to follow a particular procedure to recourse to the judiciary. So law includes both the substantive part as well as the procedural part. Now, where this law has come from, this is very much important because this basically reflects the importance of literature. Law cannot be made by the legislature within a spur of second. Law is basically the transformation of the customs, in turn, the transformation of the usages being used by a particular society at a particular time and place. For example, a particular society has certain rituals and they follow it for a prolonged period, and those rituals have become their identity. These rituals then get drafted into rules and regulations and they form the law. Then the next point in this is these rules and regulations, which are meant for the citizens, they not only includes what the citizens has to do, but they also include what they don't have to follow. So they include both the acts as well as the omissions. And the last one is law is basically the clarity, the logical interpretation, and a particular pattern of drafting. So this is a glimpse about what is law in Indian context. Now, let's switch over to the literature. When we talk about literature, we basically talk about artistic work, be it a novel, be it a play, be it a poetry. And it is basically the creativity, the description, the narratives, the imagination, the fiction, the abstraction that covers up the ambit of literature. It is to be noted here that when we talk about law, law is based upon rules and regulations, what is legal and what is illegal. And we don't have the concepts like moral, good faith, or conscience, or goodness when we talk about law, because law is what is given in the books. So the question arises, where this moral act done in good faith by a person without knowing the consequences, act done in good faith by X, believing in what has been said by B. So this moral goodness, good faith, these particular features in the law has been taken by the understanding of the literature. For example, during the time of independence in India, sati pratha and child marriage were considered to be legal. They were not considered to be illegal because the society believed it to be good for the betterment of the society. But if we talk about particular these particular traditions of sati pratha and child marriage, they have been considered to be illegal at the moment, and there are punishments for it, because in the present century, the societal bent of mind, the society is not reciprocating to sati pratha and child marriage, and it is not considered to be moral, it is considered to be immoral. So these concept of moral goodness and good faith, this has been derived from literature, and this plays a very important role, especially when the judges have to decide the cases. Now, to make it more clear where the law is in literature, let's talk about it. Usually, when we talk about law in literature, we are not talking about the complete scope of literature. We are talking about the legal literature. There are so many novelists, and there are so many contributions by the writers, very famous writers, especially Charles Dickens, who has written a lot of legal literature during the 19th century. And what they have written is not something which they have imagined all the time. See, when somebody is writing a write-up, be it a poetry, be it a drama, be it a fiction, be it a novel, his emotions are affected by the surroundings, the society. So whatsoever a writer was writing in his century, he was writing what he was experiencing along with his imaginations, what can be the consequences of these kind of things in the society. And that was, although the writer was not knowing at that time, but that was contributing to enrichment of legal literature. Now, where it is, let's go in deep. Legal literature can be in the form of legal themes in dramas, legal theme in novels, legal theme in the short stories. And there are so many situations which have been mentioned and discussed by the various novelists during their course of writings, including discrimination. So they were writing about discrimination. Today we have anti-discriminatory laws. They were talking about equality, and we have Article 14 of the Constitution dealing with the right to equality. They were talking about jurisprudence in their novels, in their writings, in their write-ups. And jurisprudence is a subject in law, that is the journey of law, and it is purely based upon the political thought, the literature. Then they were talking about the child crimes. We have labyrinth of laws at the moment, both civil and criminal, dealing with the child crimes. They were talking about domestic relations. At present, we have the Domestic Violence Act. They were talking about wars, and we have the war crimes. And they were talking about how the trial is being conducted inside the court. And we have a proper criminal procedure which reflects upon how the trial is being conducted. Not only this, there are so many literary quotes which have been mentioned by the judges time and again while deciding the cases, be it the quote related to life, justice, mercy, morality, womanhood, and responsibility. Let's talk about very famous quotes which are being seen in all the judicial offices and in the law colleges, and which are purely literary quotes, work of literature being done by the writers. For example, as Cicero has remarked, in times of war, the law falls silent. In the words of Jonathan Swift, laws are like cobwebs which may catch small flies, but let wasps and hornets break through. Then Mark Twain said, more than 200 death penalties are gone from the law books, but the text that authorized those remains. And this one is a very famous one. It is being followed in the courts at the moment, also given by Gladstone. Justice delayed is justice denied. So the cases should be solved at a speedier form. Then Charles Dickens once remarked, if there were no bad people, there would be no good lawyers. W.S. Churchill said, if you have 10,000 regulations, you destroy all respect for the law. Then Lord Denning once remarked, one thing a judge must never do is to never lose his temper, and it is being followed by the judiciary at the moment also. Then William Shakespeare has said, the upright judge condemns crime, but he never hates the criminal. And this is also a legal principle being followed by the judiciary, the judges, while deciding the cases. And then we have the statement given by Martin Luther King, injustice anywhere is a threat to justice everywhere. So we can have an idea that literature plays a very important role in the formation of law, we can say that. We have so many write-ups of very famous authors where they have talked about the law. They somehow helped in the origination of law on a particular thing. For example, in the work of William Shakespeare, in The Merchant of Venice, William Shakespeare is talking about how the contract is done. And we have a subject called as law of contracts. Then in Bleak House, Charles Dickens said, and talked about child abuse, and today we have laws related to it, and it is considered to be illegal. Then Foster once remarked in a passage to India about the due process of law. Due process of law means law as it is formed, and due process of law is an American concept which is also imbibed in Article 14 of the Constitution of India. Then in the trial, Franz Kafka, he's very famous and he has been mentioned by the judges time and again in their judicial pronouncement. He talks about the trial. In the trial, he talks about the courtroom, that how the procedure takes place inside the court. What is the procedure for the civil cases and for the criminal cases? Then Thomas Hardy in Tess talked about prosecution and unfair judgments, which is a very common phenomena in the present judicial system as well. And finally, in Resurrection, Tolstoy talked about criminal case trial by the judge. So we can have an idea that there is a very strong interrelationship between the two concepts. Now, let's see, the other aspect of literature is translation. And let's see how this translation is existing in the Indian legal system, in the Indian context. See, whenever a case comes, whenever a complaint is being filed by a person inside the police station, or in the form of an FIR, or a complaint has been filed to the magistrate, or a person is narrating what has happened with him. The victim is narrating what has happened with him to his advocate. So what actually he is saying is his experience, which is not a good experience. That's why he's approaching to the police station or to the magistrate or to the lawyer. And he is narrating his experience, which is being understood by either by the police authorities or the magistrate or the lawyer, as the case may be. And that experience is being translated by these people into the factual elements on a paper, and they write it. And this translation of the experience of a person. Same was happening with the writers also. They were experiencing what was happening in the society, and they were writing those into factual elements and on a paper, and that become the dramas and the novels and the poetry, and we characterize them as revolutionary poets, kind of stuff. So the same thing is happening in law as well, but here it is not the drama and the poetry, but you can say that these experience, it is a kind of story being narrated by the victim to the police authorities or to the magistrate or to the advocate, and they are converting it into first information report by the police or a complaint which is being filed to a magistrate, or in the form of a petition or a brief which is being filed by a lawyer inside the court, be it a civil petition or it is a criminal petition, depending, varies from case to case, and the experiences being experiences of the victims. So in this way, somehow directly or indirectly, literature is involved in law. Now, since time immemorial to the present century, there are various stages of translation being observed in the Indian context, and the most prominent of them was the first stage during the emergency times. At that time, there were some allegations being made against the police authorities that they are fabricating the experiencing being narrated by the victims to them while filing the FIRs on their behalf. So here a commission was set up for the inquiry called as the Bhargava Commission. And the Bhargava Commission on its inquiry find out that there was fabrication of the facts done by the police, who were translating and retranslating the experiences into the facts which were not present actually. So they were just imagining and aggravating the situation at that time. Second stage of translation was observed in a leading case of Premananda. I think everybody might have heard about him. Premananda, who claimed himself to be self-good man, and he was saying that he was having monopoly over certain things he can do that normal people cannot do. So whatever he was imagining and he was saying and he was putting in his petition, to confront that, court performed. The court took help of performance of experience to aid the translation done by him. And that performance was done by calling the magician inside the court, where the judge asked the magician to do the same things. So this is also a very famous example. Then the third stage of translation was the stage of the India struggle for independence, that is the British regime. At that time, there were charges against many of the revolutionary writers and poets as being anti-constitutional or anti-social or writing against the nationality or India. Although we were not independent at that time, but one of such case was against Chera Banda Raju, who was a famous revolutionary poet. And here, when his poems reached the court, here the judge asked him to narrate them. And when he narrated it, the judge came to the conclusion that it is nothing else but the Constitution itself. The fourth stage again relates to the revolutionary writings during the India struggle of independence, where the poets and the novelists and the dramatists were writing what they were experiencing in India. And that led to many social movements. And even today, we have to know about what was the law prevalent, what was legal and what was legal. We don't have any, we take a lot of help from the literature beside the acts which were made at that time. So directly or indirectly, the acts which were made to regulate a particular kind of social norm at that time was nothing else, but it was from the literature only, which were reflecting what the society feels and what the society wants. Translation, and it is being exercised by the judges inside the courtroom. Whenever a judge decides a case, the judge cannot decide a case just going through what petition has come to him. whenever he has to, because the petition which has come to him, it is just some imaginary and some experience being put into factual information, but to decide that, the judge takes help of the judicial precedents. Judicial precedents basically refers to the previous German judgments given by the judges, the landmark cases which have been previously decided by the judges on the same kind of issues which appeared in the court of law at some point of time. So these judicial precedents are nothing else but the legal literature. And this legal literature not only help the judges, but even the petitioners, the advocates, in developing their legal skills, drafting skills, understanding the technicality of the law, so as to plead the case of the victim and to reach at the point of judgment in a logical way. Now, let's take some examples of where the judges have openly used literature in judgments, especially the literature of Milton, Shakespeare, Kafka, and Orwell. If we take a look towards the application of literature, we'll find that in Constitution of India, which is also called as the Law of Land, is the first very document and the most important document where literature, legal interpretations have been used to a great extent. Constitution, there is no uniform way to interpret the Constitution when we read it and when the judges read it or the advocates read it. It can have the literal interpretation also, that is word to word what is written, so as to proceed further with what the drafters were imagining and what the drafter of the Constitution wanted to say. Or with the changing society, it can have a liberal interpretation also. And this liberal interpretation is nothing else, but it is based upon legal literature. It is basically the legal literature. So this is the area of liberal interpretation of Constitution, keeping in mind the present society. And that is being done. Why it is done? It is being done to understand the facts, to support the legal reasoning, and to reach at a judgment which is beneficial for both the parties, right? And it also makes the judgments effective. It also makes the judgment landmark. So many cases are being decided by the judiciary every day, but only certain cases becomes the landmark judgments. And these are those judgments which have a direct nexus with the societal norms, uh, So here legal interpretation and legal literature plays a very important role. Now let's talk about certain case laws where openly literary quotes have been used by the judges in the judgment part. In the leading case of D.D. Basu versus State of West Bengal, which was a case related to arrest, custodial violence, and torture, when the judge was inquiring about the case and the petition was being filed and the trial was carried out, it was found that torture was not defined at that time inside the Constitution of India, and still it is not being defined. So here the judge relied upon in the judgment, he has mentioned the words of Adriana P. Barto: torture is despair and fear, and rage and hate. It is a desire to kill and destroy, including yourself. Then switching to the next judgment, we have the judgment in the case of Aruna Ramachandra Shanbog versus Union of India of the year 2011. Everybody knows about it. It was a case related to assisted or passive euthanasia, where the victim was asking for assisted death. So in this case, it was a very debatable case, and because the judiciary was considering it to be against the right to life, and the judgment was given in 141 pages. But this judgment also started with a literary quote by Mirza Ghalib: मरते हैं आरज़ू में मरने की, मौत आती है पर नहीं आती, which means one dies longing for death, but death, despite being around, is elusive. So we can have an idea that how much impact the judges have of literary legal literature and the legal literature write-ups of the various novelists and poets on their judgments as well. And we have Justice Kaju, who is quite close to, we see his articles every time in the newspapers. And whenever he's mentioning something or he's writing, and if we go through his judgments also, we'll find the mention of Bhagavad Gita, Upanishads, and Quran, which are a literature. Then we can also talk about one more case of related to Aadhaar card. I'm giving you those examples which you can understand even if you're not from law background, so that you can have an understanding that how literature is also playing a role in it, although it is understood that literature has no part in it. This was a case of Justice K.S. Puthuswamy, retired, versus Union of India of the year 2012, where Aadhaar, uniqueness of Aadhaar card came into question. Why Aadhaar card should be there? So here also the judge said that it is better to be unique than the best, because best makes you number one, but unique makes you only one. So it is also literary code. And then we have a case related to homosexuality of Navtej Singh Johar, 2018. Here also the judge quoted literary classics such as Oscar Wilde, who himself has been prosecuted for homosexuality. So we can conclude that the skillful judge, like the skillful detective storyteller, keeps the reader reading, because the case is nothing else, it is a kind of novel. He keeps the reader reading by deferring announcement of the resolution to the end of opinion, reaching to the decision in just like going through a novel, reflecting on close proximity between law and literature, especially in terms of reading of the text and the interpretation. So this is my conclusion, that literature is an indispensable part of it, and no judgment can be given by the judiciary if the judge will not go through the logical interpretations of what the write-ups have been given by the novelists and the poets during their time. Uh, that's it. Thank you so much. Jai Hind.
Thank you, ma'am, for igniting us with new thoughts.
Thank you so much. My pleasure.